And now I would like to introduce our next speaker, Raquel Ukeles, who is curator of the Islam and Middle East collection of the National Library of Israel, focusing on developing Israel's main research collection in these fields and on building cultural and educational initiatives on Islam, the Middle East, and Arab culture in Israel. Raquel graduated from Princeton University and received her MA and PhD from Harvard University. She has also studied Islamic law and Arabic in Egypt, Morocco, and the Netherlands. She had been assistant professor of religious studies at Fairfield University in Connecticut, teaching Islamic studies and comparative religion. She was also Golda Meir postdoctoral fellow of the Hebrew University in Jerusalem between 2008 and 2010. Her publications include several articles on jurist responses to religious innovations and a monograph on Islam in America post 9/11.
On Friday, March 18, 2005, Dr. Amina Madood, an African-American Muslim scholar, led a mixed-gender congregational Friday Jummah prayer in New York City. Although women had led mixed prayer groups on a number of occasions since 1994, primarily in South Africa, the US, and Canada, the New York City prayer drew intensive and extensive media coverage and sparked a global intra-Muslim debate on the legal question, can a woman be an imam of a mixed-gender Jummah prayer? One might even say that the organizers of the event, the now defunct Progressive Muslim Union, designed such a high-profile event to encourage or even provoke such a discussion. The overwhelming majority of Muslim scholars, both in the traditional Muslim world and in the West, wrote against the validity of women-led prayer for men. Opponents argued that one cannot change a law of worship, which in this case is based both on juristic consensus, ijma', and on the continuous religious practice of Muslims from the Prophet Muhammad's time onward. A few scholars in the US and Europe wrote in support of women imams, with some arguing that the Prophet actually permitted women imams for men, while others asserting that the historical juristic prohibition derived not from religious texts, but from social conventions that can change according to a community's needs. The debate over women imams highlighted vastly different approaches to engaging the Islamic legal tradition and to changing the laws of worship, particularly when it intersects with gender roles. No? The international debate over women imams brought into contact Muslims from a wide range of backgrounds wielding very different types of religious authority. These Muslim experts produced two kinds of writing. First, legal scholars with official positions as fatwa issuers, such as Egyptian Mufti Ali Gouma, the former late Sheikh al-Azhar Mohammed Said al-Tantawi, the Mufti of Saudi Arabia Abdullah al-Sheikh, and Yusuf al-Qaradawi, head of the European Council of Fatwa and Research, published fatwas, as have a number of other Islamic legal councils both in the US and the Islamic world. Among American Muslims, some scholars who have completed degrees in Islamic law in Middle Eastern madrasas, such as Muhammad Nur Abdallah or Khalid Abul Fadl, and I'll explain more about them later, they also published fatwas. However, many of the texts written by Western Muslims took the form of an article. Some of the writers are Muslims who derive their knowledge and authority from a secular university as opposed to a madrasa, such as Professors Nevin Reda, Hina Azam, Ingrid Mattson, Mohammed Fadil, Laurie Silvers, and more. At the same time, even the madrasa-trained African-American Imam Zaid Shakir chose to express his remarks in a paper that he labels an examination, as opposed to a fatwa, perhaps to reach a broader audience. Regardless of the source of authority or genre, the texts of this debate have been disseminated primarily through the internet. In other words, the internet has enabled a global Muslim debate that blends generally distinct universes of discourse and enables a cross-cultural comparison of legal approaches. The debate over women imams for mixed prayers, from here on in I'll just refer to women imams, but I'm specifically talking about prayers where women lead men, unless I indicate otherwise, enables us to explore how changing conceptions of gender roles, especially among American Muslims, has affected the ways that these scholars consider the parameters of legal change with regard to ritual. For some American Muslim scholars, their egalitarian conception of gender roles, i.e. that men and women can perform public roles interchangeably, reflects a broader project of reconceptualizing Islamic law. For others, particularly among American Muslim opponents of women imams, their writings betray a tension between their espousal, at least rhetorically if not substantively, of gender egalitarianism on the one hand, and a resistance to changing laws of worship that exclude women on the other hand. In either case, attitudes towards gender posited in most American Muslim writings sharply diverge from the discussions of many Middle Eastern scholars who assert the value of gender equality in the sense of the equal value of women and men before God, while simultaneously upholding patriarchal attitudes towards gender roles. The intersection between gender and ritual in the case of women imams reveals a growing cultural gap, a gap in cultural values between these two Muslim communities, even while most agree, for now, on legal rulings. Before turning to the writings on women imams for mixed gender Friday prayers, I will first situate the debate in the context of Islamic feminism on the one hand, which is the ideological ground for many proponents, and the context of American Islam, where the debate has been by far the most extensive. In the written version of this paper, I examine in more detail the writings both of Middle Eastern scholars and of American scholars. Here I will focus primarily on selected American participants in this debate and highlight key differences in their approaches and values. Given the audience sitting around the table, I don't want to spend too much time. I think this is basic ground for all of you. But the Islamic feminists place themselves as heirs to the movements of reform that, of course, began in the 18th century, but in the 20th century have taken a number of forms themselves. The shared features of these reformist movements, which are very important for understanding the moves, both rhetorical and substantive, of Islamic feminists, a rejection of taqlid, a rejection that they are beholden to the traditions of jurisprudence, a return and a feeling of empowerment to be able to read the Quran and Hadith directly, and, as we will see again and again, an emphasis on maslaha, the community interest. Of course, there are key differences between the Salafis on the one hand, the modernists, and the Islamic feminists, which I think will become very clear. Behind all of these issues, of course, is the question of authority. Who has the authority to interpret the tradition, to decide, to make rulings? And this becomes a particularly poignant question in American Islam. But before that, let's talk about Islamic feminism. Islamic feminism as a discourse has developed over the last 2 decades, and Margot Badran has been one might say the pioneer on defining and identifying this discourse in these movements. I would say that the main writings in favor of women imams are best understood as a reflection of Islamic feminist values and the application of hermeneutical and rhetorical methods developed by Islamic feminists over the past 2 decades. As Margot Badran explains, and here I quote, Islamic feminism is a feminist discourse and practice that derives its understanding and mandate from the Quran, seeking rights and justice within the framework of gender equality for men and women and men in the totality of their existence, and calling for the implementation of gender equality in the state, civil institutions, and everyday life. Islamic feminists thus differ from other feminists who happen to be Muslim in that their activism stems from their interpretation of basic Quranic sources and values. As heirs to modern reformist movements, Islamic feminists feel empowered to read directly the Quran independently of the subsequent tradition of interpretation, whether it be tafsir or fiqh. But in contrast to the Salafi movements, they distrust the written hadith traditions. And they seek to locate, to identify and locate the original values of the Prophet through what I might call the thicket of patriarchal norms, which are found in the written transmissions that they would argue sullied the Prophet's original liberal teachings. Islamic feminists share the common Muslim understanding that the Quran reflects God's own attributes of oneness, tawheed, and justice, adl. For Islamic feminists, however, these attributes lead logically to the rejection of any form of hierarchy, and specifically to the rejection of patriarchy, that is, the superiority of men over women, in favor of mutual dependency and egalitarianism in all public roles. As leading Islamic feminist Amina Wadud, and yes, she was the imam in the New York City prayer, she explains, a corollary of God's tawheed, his oneness, is that all human beings are of equal significance. And here I quote from a book called Inside the Gender Jihad, if human beings really are horizontally equal, independent, and mutually codependent, each has the same potential for performing any social, religious, political, or economic task. Wadud's understanding of Quranic values leads her to reject the traditional differentiation of gender roles when it comes to ritual. The cultural, again I'm quoting, the cultural and historical precedent of exclusive male leadership in the role of religious ritual is not a requirement. Although it has served as a convenience, which later became legally inscribed, it was merely customary and should not be prescribed as a religious mandate. I'm sorry, this is by far the best I've sounded in a few days. As we will see, the main arguments in support of women imams rest on these two notions, that the Quran mandates equality between women and men in the fulfillment of religious obligations, and that the exclusion of women from religious leadership roles stems from the post-prophetic social patriarchal norms. Now to a little bit about the American context. This is a professor of Islamic law who is an American Muslim, Kisha Ali, and in the preface to her book called Sexual Ethics in Islam, she writes, which I think is a great summation of the position of Islamic law in America. Living in a nation where Islamic law has no coercive power, regardless of its moral weight for individual believers, I write as one with the luxury of deciding whether or how to apply religious doctrine in my own life, whether to arrange my affairs to follow the dictates of one or another school of jurisprudence or the regulations in the Quran, or to follow civil law. When it comes to the United States, the state, the government, does not intervene at all in the establishment of religious organizations. There is no official Muslim representation. There are many Muslim organizations, but they reflect the profound diversity of Muslims in America, perhaps the most diverse Muslim community in the world. Hopefully you can see, this is just the largest groups. The main thirds are Arabs, South Asians, and Middle Easterners. Arabs, South Asians, and African Americans, sorry. But there are representatives from almost all of the Muslim countries all over the world living now in America. So why has this debate, which started out in America, became global for a while, but continues to be an issue of interest and concern in the United States? So first of all, the issue that Islamic law is voluntary or personal. It doesn't have the state power. Number two is that everybody's new, with the exception of the African Americans, who are not new to America, but they're new to Islam. There's no entrenched madhab. There's no traditions of jurisprudence. And because of the diversity, the Quran and the Hadith are the one link between and among all the Muslims. And Salafi groups have been very active in America and promoting this idea of the return to these canonical sources. And so there's a kind of natural impulse to go directly back to the Quran and to the Hadith. And then I assume this is true in Europe as well, but I would love to hear it. And that is that the imam for Middle Eastern countries, which sometimes plays a pastoral role, but doesn't necessarily, serves primarily as a leader of prayer, has taken on a heightened importance in America as primarily non-Muslims Americans look to see who represents the community. And this was particularly strong right after 9/11, where there was a scramble on the media to speak to Muslim representatives, and suddenly you have all these very small organizations, some described as two guys in a fax machine, who suddenly are the official representatives of Muslims in America. And then the question of, well, who leads your church, right? Well, the imam. Well, who's the imam? Suddenly that becomes a much more important role, and why can't women play that role? What's striking also about the American context is you have the participants in the debate come from very different types of institutions with different types of expertise, or one might say authority. You have a very prominent role of Muslim academics in secular institutions. Of course, you have a lot of women. I just listed a few of them, but there are easily 5 more who have been active in this discussion. You have community imams, some trained and many trained in the Middle East. These are particularly prominent ones. We'll come back to Zayd Shakir. And then you have the Fiqh Council on North America, which was created by the Islamic Society of North America. That organization was in turn created by the Muslim Students Organization Association, which was the earliest cross-America organization because it was founded by primarily Middle Eastern students who came to graduate school in America, and then they grew up and they needed another organization. That is by far the largest organization of, I would say, Muslims from immigrant backgrounds. This is an 18-member body. It has no authority on its own. It provides non-binding opinions, fatwas, official declarations when called upon it. But one can't say that it functions like a state mufti or anything near that. Okay, let's go to the debate. The writers in support of female-led mixed-gender prayer share a number of common arguments. First, they point out that there are no explicit texts from the Quran and from the Hadith that prohibit women leading men in prayer. Second, they say that there's general evidence from the Quran that both men and women are obligated equally to fulfill religious duties. Third, they locate a precedent for women imams in the Hadith that Muhammad appointed Waraqah, a companion and a female collector of the Quran, to lead a mixed-gender prayer. Moreover, several early scholars, such as Abu Thawr, al-Muzani, Dawood al-Isfahani, al-Tabari, and later Ibn Arabi, used this hadith as the basis of their support for women leading men in certain prayers. The early support of these scholars both attests to the relevance of this hadith of Waraqah as a general precedent and undermines the opponent's claim to juristic unanimity against the prayer. The presence of general support from the Quran and Hadith and the absence of an explicit textual prohibition lead these writers to conclude that the majority legal prohibition against women imams stems not from textual evidence, but from social custom. Naveen Reda wrote an article in support of women imams for mixed-gender congregations called "What Would the Prophet Do?", which is a play on a common American trope, what would Jesus do? The Islamic basis for female-led prayer. It was the most widely circulated text in support of women imams to date. Reda, an Egyptian-born Canadian Muslim, wrote the bold and one might say provocative piece while completing a doctorate in Quranic studies at the University of Toronto in Canada and is now a faculty member of Emmanuel College in Toronto. Reda argues that women have a fundamental right to lead prayers based on the Quranic values of gender equality and the Prophet's own behavior, but that male scholars throughout history have prevented women from actualizing their right because of patriarchal conventions. She posits that while the Quran does not offer guidance on the gender of the prayer leader explicitly, and now I'm quoting, God affirmed the suitability of women in major leadership roles through Quranic verses praising the political leader, the Queen of Sheba, and the religious leader, as she calls her, Mary. Reda also uses verses from the Quran to articulate the core value of gender equality, citing verses criticizing the cultural preference for male children, and a verse addressing both men and women to uphold and fulfill religious duties. While the Quran does not provide explicit support for women imams, the hadith literature, and specifically the hadith of Waraqah, serve as clear textual proof, according to Reda, that the Prophet did appoint women as prayer leaders for mixed gender groups. Now, this hadith became the cornerstone of the women imams debate. I would say 10 years ago, very few people in the world ever heard of Waraqah. But as Yulia Hammer, in a book on women, Islam women and authority, she notes that the debate has become as much about how to read the hadith tradition and how to juxtapose the hadith traditions with the juristic rulings later on, and as much about that as the content of the hadith. But I don't want to spend too much time on this, but I do want you to have a basic sense of what the hadith says. Now, the hadith is found in 3 variations in numerous collections. The first is from Sunan Abu Dawud, which of course is one of the 6 canonical collections, but doesn't have the authority of Bukhari and Muslim. Waraqah asked Muhammad for permission to join his raid at Badr. The Prophet responded by ordering her to stay home. Then the tradition relates that she asked permission to have a muezzin in her house. And the Prophet granted her permission, the latter of which is understood by interpreters to mean that she conducted her own prayer service. Later on in that hadith, someone is cited as saying, and I saw her muezzin and he was an old man. And also a second version of this hadith in this collection cites that in the household there were at least 1 male and 1 female servant, which is how they know it's a mixed gender prayer. In contrast, the version brought by Ibn Sa'd and in his biography and in the Musnad of Ahmed ibn Hanbal, this variation implies that Muhammad had ordered her to serve as imam prior to the episode at Badr, and for that reason she wasn't permitted to join the Badr campaign. I have the longer version here. The messenger used to visit her, and he named her a shahida, the martyr, and she was one of those who collected the Quran. During the period of the raid on Badr, she asked the messenger, "Will you permit me to go out with you and tend your wounds and heal your sick? Perhaps God will grant me martyrdom." He replied, "Indeed, God will grant you martyrdom," and from then on he called her the martyr. The messenger had commanded, which is the past perfect, had commanded Waraqah to lead the people of her dar, of her house, or sometimes defined in her area, in prayer. She had her own muezzin. Finally, a third variation on this hadith is quoted by Daraqutni, stating that Waraqah served as the imam for her household, but only for women. Although all accounts agree that Waraqah led obligatory prayers that required a muezzin, they differ as to whether she led a mixed-gender prayer or a group of women. Parenthetically, a number of scholars of hadith transmissions questioned the probity of one of the main transmitters and also the identity of 2 others, but despite its weak status, the hadith was transmitted broadly because its subject was well known. Reda reads the case of Waraqah as establishing a general precedent for all qualified women to lead men in prayer. In her interpretation, based on Ibn Sa'd's version, which is the second version, the Prophet commanded a woman to be imam and that her duty as imam took preference over another religious obligation, that is jihad. This narrative strengthens the idea that Waraqah's position as imam had official status and was not a one-time exception to a general rule against women prayer leaders. When turning to the question, whom did Waraqah lead, Reda relies on a broad understanding of the term dar to mean neighborhood or area, and posits as opposed to household, and then posits that Waraqah turned her home into what she calls the second mosque in Medina, where she led mixed-gender prayers. Sorry, that's the third one. For Reda, the hadith of Waraqah indicates the Prophet's position on women imams in general. In light of the above, when the need for a second mosque arose, the Prophet chose a woman to act as the imam. his statement indicates his position when it comes to women leading men in prayer. We should not be stating that he did not allow it and thereby present a false and misogynistic image of the Prophet. This is language that you see across Islamic feminist writings, that the Prophet is a kind of proto-feminist, a hero, but that his feminist inclinations were muted and removed by the surrounding patriarchal culture, and then once he passed away, it was removed altogether. The proof for that is, of course, that the Prophet Muhammad allowed and possibly encouraged women to go to mosque for prayers, and then after he died, that all but disappeared in the Muslim community. In addition to affirming the hadith of Waraqah as textual evidence in favor of women imams for men, Reda rejects the relevance of other traditions cited in this debate, either that denigrate a woman's suitability to lead men or that limit the place of women to the back of the mosque. There are several, so I'll just mention the one transmitted by the companion Nufay bin Masruh Abu Bakr, who died in 671-72, which appears in the canonical collection of Bukhari. The hadith states, when news reached the Prophet that the Persians had appointed the daughter of Khusro their rulers, he said, a people will not prosper who give the ordering of their affairs to a woman. This tradition, which historically has been used to challenge women's leadership in all domains, has been the subject of much attention, as you can imagine, by Islamic feminists. In her refutation of the hadith validity, Reda questions the probity of Abu Bakr and argues that he is an unreliable witness. Reda here demonstrates a willingness to challenge the sacred authority of Bukhari. Taken altogether, the lack of an explicit, credible textual source that prohibits women prayer leaders and the presence of general Quranic support and the explicit prophetic precedent of Waraqah, all these factors lead Reda to conclude that the exclusion of women imams is a later attempt by primarily male scholars to cover up the original intention of the canonical sources. Given textual support, the majority juristic opinions against women imams for men can be understood only as the well-intentioned mistakes of previous generations based on their social context. Reda similarly dismisses the relevance of arguments regarding sexual fitna as an outdated social convention. Reda argues in conclusion, using clearly reformist language, contemporary Muslims should not be enslaved by ancestor veneration and should restore the Prophet's original practice. Turning now to the second proponent that I'll look at, Khalid Abul Fadl. Among the writers in support of women imams, only Khalid Abul Fadl is a legal scholar with a training from a traditional Islamic madrasa in the Middle East. Abul Fadl was born in Kuwait and raised and educated in Egypt. He's both a professor of Islamic law at UCLA and has a following among certain American Muslims as a mufti. In a fatwa published on a website maintained by his students and followers, Khalid Abul Fadl responds not to the March 18th event, but to a case of a small group of Muslim students who gather for Friday congregational prayer, in which there are 3 girls who are, quote, most informed about Islam and able to lead prayer, as well as 2 Muslim adolescent boys. Can the girls serve as imams for the group? Abul Fadl responds first by outlining his understanding of the role of the imam for the Friday prayer, and then by addressing the legal question of a woman's permissibility. In Abul Fadl's assessment of the classical tradition, the imam ideally should resemble a community leader rather than a religious functionary. This conception of the imam sets the stage for allowing women to be imams, provided they are the most qualified instructors of religion. In his analysis of the legal evidence, Abul Fadl draws attention to the gap between the predominant juristic position against a woman imam for men and the relatively scarce textual evidence. He acknowledges that the vast majority of jurists throughout Islamic history have ruled against women ever leading a man in public prayer. According to Abul Fadl, although there were at least 2 early schools that allowed women to lead men in prayer if they were the most knowledgeable, these schools became extinct in the 10th century. However, Abul Fadl argues the canonical sources do not provide clear evidence for the jurist rulings. As he writes, the Quran itself does not mandate that only men be allowed to lead prayer. The Sunnah is indecisive on this issue. While he does not mention Waraqah by name, Abul Fadl evokes the hadith when he adds, quote, there's evidence that the Prophet on more than one occasion allowed a woman to lead her household in prayer, although the household included men, when the woman was clearly the most learned in the faith. Here, Abul Fadl presents a much more restrained reading of the Hadith of Waraka than does Nevin Reda. Not only does he understand the term dar to mean household as opposed to neighborhood, but Abul Fadl regards this as an example, but not a general precedent. Although he does not address any other Hadith traditions here that have been cited by opponents, elsewhere, Abul Fadl discusses at length the Hadith of Abu Bakr on women leaders and explains there, while there are too many questions about whether this particular statement stems originally from the Prophet for the statement to have such broad normative weight. Given the dissonance between the overwhelming juristic position against women imams and the lack of strong textual evidence in that direction, Abul Fadl concludes that the prohibition must derive from social custom rather than a religious norm. And here I quote, "But the question is there a specific exclusion against women when it comes to prayer? It seems to me that if there is such an exclusion, the evidence in favor of this exclusion ought to be strong, if not unequivocally so. But the legal evidence in favor of such an exclusion is not very strong. It is more an issue of customary practice and male consensus than direct textual evidence. Consequently, in my opinion, priority ought to be given to what is in the best interest," and here's that term maslaha, "of the community, and knowledge is the ultimate good." Abul Fadl, like Amina Wadud and Nevin Reda, assumes a general Quranic value of gender equality when it comes to religious roles. In the absence of a clear textual prohibition, the core value stands. Once Abul Fadl identifies this matter as an issue of customary practice, and rather than textual indications, he is then able to assess the case from the lens of community interest. Since the Imam in Abul Fadl's reading of the classical tradition essentially is a community teacher, it is within the community's interest to benefit from the most qualified teacher, whether male or female. Abul Fadl does address the concern for preserving norms of modesty, but unlike his Middle Eastern colleagues, does not see the concern for modesty as an insurmountable obstacle. Instead, Abul Fadl stipulates that a woman imam should not stand in front of the men, but on the side, as mandated by the early schools of law that permitted women imams, and according to the practice recorded about the Prophet's wives, who led other women in prayer. As we have seen, both Reda and Abul Fadl argue that the juristic ruling against women imams for men stems from social convention and not from textual sources. While the subject at hand, prayer, clearly falls under the realm of ibadat, of devotional practices, the exclusion of women should be evaluated as a social issue and not a devotional one. That is, unlike other matters of ibadat in which the effective cause of the ruling is not intelligible, in this case, Abul Fadl, Reda, and others would argue that the cause of the ruling is intelligible because it stems from a social norm and not from divine reasoning. As such, the law is subject to reinterpretation using the lower standard of proof for social matters, mu'amalat or adat. The lack of an explicit textual source against women imams, a point that opponents will admit as well, serves as confirmation of their assessment, and for Abul Fadl, the grounds for evaluating the issue on the basis of community need, maslaha. As we will see, all opponents of women imams deal implicitly with Abul Fadl's argument when they assert that gender roles as a matter of worship do not derive from social custom and thus are not subject to arguments for legal change on the basis of social good. All opponents of two women imams reject the validity of women-led Friday congregational mixed-gender prayer because it constitutes a change in the laws of worship, ibadat, and because it violates a precedent set by the Prophet and confirmed by jurists throughout Islamic history. When it comes to prayer in particular, these scholars view the Prophet's normative practice as exhaustive. In the words of Muslim academic Dr. Hina Azam, we submit to the form of the salat that the Prophet did and pray as he did. While many scholars admit that no authentic textual source prohibits women from leading men, they also assert that the standard of proof required for ibadat demands the existence of a textual source that permits explicitly women imams for men in public prayer. The Hadith of Waraka, contrary to Reda's position, does not meet that standard. Since no such text exists, the prayer of a women-led Jummah is invalid for male participants, and in the writing of many scholars, an innovation, a bid'ah, that deviates from the true religion. Although opponents of women imams for men share this basic argument, clear differences of emphasis emerge between the writings of Muslims from the Middle East and those from American Muslims. Most Muslim scholars from the Middle East base the legal prohibition on the concern over sexual fitna, that a woman imam will stimulate and thus distract men from prayer. Yusuf al-Qaradawi, in particular, uses the issue of sexual temptation as the effective cause for determining when and where a woman may lead prayers. In his widely circulated fatwa, al-Qaradawi writes, "Prayer in Islam is an act that involves different movements of the body. Moreover, it requires concentration of the mind, humility, and a complete submission of the heart to Almighty Allah. Hence, it does not befit a woman whose structure of physique naturally arouses instincts in men to lead men in prayer and stand in front of them, for this may divert the men's attention from concentrating in the prayer and the spiritual atmosphere required." The former Egyptian Sheikh al-Azhar, Muhammad Sayyid at-Tantawi, argued that the proponents misunderstood the Islamic notion of gender equality before God, and that God created men and women equally, but to have different qualities and thus different functions or roles. In striking contrast, almost all of the North American opponents of women imams completely avoid the issue of sexual distraction altogether. While Zaid Sheker does invoke the concept of fitna, he pointedly defines it as creating strife in the community and not as sexual temptation. American scholars instead focus on the more technical issues of how to read sources and apply jurisprudential principles. These North American scholars end up asserting the arbitrary nature of ritual law and giving rulings with no content-based legal rationales. Several of the scholars distinguish expressly between the restrictive legal criteria for prayer leadership and, of course, the general ability of women to serve as public religious leaders. In effect, these American scholars are pulled between the egalitarian or quasi-egalitarian values that they share with women imam proponents and the loyalty to traditional jurisprudential methods that they share with Middle Eastern opponents. In Zaid Sheker, he's the imam in California, an African-American imam, very well respected. In his well-circulated refutation of Naveen Reda's article, he also focuses exclusively on issues of legal methodology and avoids discussions of sexual temptations or the different qualities of women. Sheker, an African-American scholar who is one of the most prominent American Muslim religious or community leaders in the U.S. today, is known both for his traditional training, including 7 years of Islamic sciences study in Syria, and for co-founding the first Muslim Institute of Learning. They call themselves the first American Muslim Liberal Arts College, Zaytuna, in Northern California, dedicated to teaching traditional Islamic sciences within an American context. In his article, which is called An Examination of the Issue of Female Prayer Leadership, Sheker focuses primarily on demonstrating that Reda's evidence does not support her conclusion. In his own argument on women imams rests exclusively on the consensus of the 4 Sunni schools against the validity of women-led prayer. With that, he's done. In contrast to the writings of Middle Eastern scholars who uphold the status quo for what they call the honor of women, Sheker ends his article with an acknowledgement, cited here, of the discrimination faced by women in the Muslim community and a call for greater sensitivity to the needs of women in prayer spaces and more generally. Zaid Sheker begins his article by declaring the controversy surrounding the March 18th female-led Jummah as a source of strife, fitna, within the Muslim community. But in labeling the debate of fitna and defining it as community strife rather than sexual temptation, Sheker redefines the issue away from sexual impropriety and towards a disagreement over legal tradition and legal authority. Sheker focuses his analysis on the hadith of Waraqah, which he declares to be Reda's lone substantive evidence. He devotes extensive space to refuting Reda's interpretation of the hadith as a precedent for women-led public prayer and presents 3 possible interpretations, each of which restricts the scope of the hadith. 1, that Waraqah most likely led prayers within her home by interpreting the word dar literally. 2, based on Daraqutni's version of the hadith, that Waraqah, which qualifies the other traditions, that Waraqah must have led only the women of her area. Or 3, that Waraka led only women within her household, combining 1 and 2, based on the record of other female-only congregations led by the Prophet's wives. In each of these 3 interpretations of the Hadith of Waraka, Sheker demonstrates his traditional approach to interpreting texts, preferring to rely on single versions of the Hadith, as in the case of Ad-Daraqutni, rather than his own logic or linguistic determinations. Far from Reda's interpretation of Waraka's second mosque in Medina, Sheker concludes that Waraka's the Hadith confirms other Hadith traditions of early women prayer leaders for other women. Sheker then addresses the report of early individual jurists for unrestricted women-led prayer and dismisses this support as irrelevant for establishing a legal ruling because the remaining 4 Sunni schools, as a rule, do not accept the positions of extinct schools as independently valid due to a simple methodological issue, as he calls it, namely that neither the full corpus of rulings from these extinct schools nor the details of their legal methodology have reached us in entirety. Sheker then discusses Reda's rejections of the other hadiths that impugn women leaders, place women in the back rows of prayer, or insist that women are dangerous for men. Rather than addressing their content, Sheker focuses only on their legal status. He writes, quote, "Although we could discuss its meaning, the report itself is rigorously authenticated. That is, he avoids discussing the relationship between issues of prayer and gender relations, even when presented with a clear opportunity to do so." Sheker concludes his article by differentiating between the clear legal rule against women imams, this is a paraphrase of this quote, and the social need for greater sensitivity for women's issues in the Muslim community. The dual theme of recognizing the problems faced by women while rejecting changes to the laws of worship can be found as well in other American Muslim writings against women imams. Dr. Hina Azam, a professor of Islamic studies at University of Texas, writes unabashedly of the insulting conditions faced by women in Muslim prayer spaces. That women are good Muslims when they're most silent, walls and curtains, crowded and substandard prayer areas, prohibitions from entering the main area, going through the main door, lack of comfortable or direct access to imams, etc. All of these contribute to a feeling of alienation among Muslim women. Although Azam criticizes sharply the marginalization of women in public prayer spaces, she, like Sheker, separates between solving these problems and initiating legal changes to the structure of public prayer. As she writes, all of these problems, however, should be rectified without violating the sanctity of our ibadat. Instead, Azam offers a set of practical roles for women to play before and after the ritual part of Friday prayer, to allow women to have, quote, greater visibility in the religious life of the community. By the public roles that she suggests for women to play in the mosque, Azam effectively rejects the notion that the exclusion of women from serving as imams relates either to their incapacity or to their naturally seductive presence for men. Rather, she removes any content from the legal ruling against women imams and relies exclusively on the point that the laws of prayer are immutable and unintelligible. The unintelligibility of the legal ruling against women imams echoes in a posting of the influential scholar and Islamic law professor at University of Toronto, Dr. Mohammed Fadel. Fadel, like Hina Azam and Sheker, argues that the issue of women imams rests solely on its status as a matter of ibadat. As he explains, the presumption within Islamic jurisprudence is that matters of ritual are established only by revelation, because the manner by which we worship God is completely arbitrary. In the case of ritual law, however, the only goal is obedience, and therefore it is satisfied whatever the form it takes. The only question to be determined is to find out how God wants us to discharge the specific act of worship. Far from the justifications of Middle Eastern scholars, Fadel and the other American Muslim scholars refused to provide a content-based legal rationale for the ruling against women imams. For Fadel, the lack of a historical precedent, both in the life of the Prophet and afterwards of a woman Jummah leader, serves as clear evidence that a woman imam, for some unknown reason, is not how God wants Muslims to worship. As he says, the basic problem that must be overcome with respect to women leading men and women in prayer is the fact that there were scores of highly competent, learned, and eloquent women in various periods in Islamic history, and there's no evidence that they ever thought to act as imam of men and women in congregational prayer. As his description suggests, Fadl rejects implicitly the notion that a woman would be incapable of leading prayers or that her sexuality might serve as an obstacle. In Fadl's writing, the exclusion of women from being imams is completely arbitrary and should have no logical implications. The writings of Azam, Fadl, and to a certain extent Shekir, betray a tension between the progressive values they espouse regarding gender relations and their conservative approach to changing the laws or not changing the laws of worship. Both Azam and Shekir acknowledge that their legal conclusions will prove dissatisfying for those seeking a greater religious role for women. Although these scholars reject the validity of women imams for men, Azam and Fadl both hint at the possibility of more creative legal work in the future. As Azam writes, my recommendation is that we study and critique the tradition and work on developing a legal interpretive methodology that leads to a more equitable rulings. Yes, so long as the work is done with caution and humility. Fadl, at the end of his posting, writes, quote, it's conceivable to me that one day this could be a genuine issue in which something meaningful is at stake, if it is developed organically within the community. My particular feeling, however, is that it is not ripe yet for mature consideration. Both hint at the possibility of developing a more flexible approach so long as it is done with proper intention and with sufficient understanding of Islamic legal methods. The debate over women imams thus reflects fundamentally different approaches to dealing with gender roles in ritual. Opponents of women imams reject the validity of women-led prayer for men because they regard all established aspects of prayer as part of the laws of worship. Proponents of women imams argue that the exclusion of women from leading prayers for men stems from social convention, and thus the exclusion should be reevaluated as part of social rather than sacred law. As the paper hopefully has demonstrated, this difference in categorization has significant consequences for the possibilities and requirements for legal change. For Khalil Abul-Fadl and other proponents, because gender roles in ritual are socially constructed, they should be subject to a change according to community need, maslaha, a category that since the critical work of 14th century Maliki jurist Ibrahim al-Shatibi has generally applied only to social or customary matters, adat. By the way, beforehand, that's not necessarily the case, and it's an interesting feature of this whole discussion that Shatibi's approach to maslaha, among others, has become the default method of thinking about this issue. Opponents unanimously invoke the principle that a law of worship cannot be changed. Moreover, this difference of categorization helps us understand the dissonance between the focus of opponents on the lack of explicit textual sources supporting women imams, whereas the proponents highlight the lack of an explicit textual source prohibiting women imams. These emphases reflect the different standards of proof required for ibadat as opposed to adat. The case of women imams thus sheds light both on how contemporary scholars are addressing the emerging Islamic feminist call for gender egalitarianism in religion. Finally, can one change an aspect of ritual law? The debate over women imams for men also highlights several different contemporary strategies for approaching ritual law and the possibilities of legal change. Khalil Abul-Fadl's writing on gender reflects his broader project of rethinking the nature and parameters of legal interpretation. By arguing that one can identify aspects of ritual law that derive from human reasoning or social custom rather than divine sources, Abul-Fadl downplays the main distinction drawn between the standards for changing ibadat versus adat. Instead, he focuses on the distinction between laws that are based clearly in divinely revealed sources and much of the law which is based on human interpretation and thus subject to re-examination. Unlike Abul-Fadl, who regards both gender roles and much of Islamic law as dynamic, the Saudi and Egyptian scholars surveys assert that both gender roles and the laws of ritual are static and unchanging. Finally, a number of American Muslim opponents of women imams reflect a complex relationship by acknowledging the changing and social aspect of gender roles and yet maintaining a static approach to Islamic ritual law. The case of women imams reveals a growing cultural gap between Middle Eastern scholars and American Muslim scholars when it comes to gender roles. Although many American Muslims share the patriarchal attitude of their Middle Eastern counterparts, evidenced by the manifold problems for women in prayer spaces in America, there is a growing cadre of American Muslim scholars who combine a commitment to traditional Islamic law with a tacit or explicit espousal of egalitarian values. It should come as no surprise that most of them are academics of Islamic law in secular universities in America. The surprising element is their growing influence in segments of the traditional American Muslim community that are also sympathetic to expanding religious opportunities for women. It remains to be seen whether this group of American Muslim scholars will engage in laying a more mainstream approach to legal change when dealing with gender issues. Thank you. There have been continual events. There have been continual prayer groups that are meeting in the States.
In the same place, in New York?
In New York, they met, I think, where did they meet? In the Riverside Church or Presbyterian Church. They were supposed to meet in a gallery in downtown Manhattan, but they received a bomb threat a few days before, and so they moved it to a church, which was not an ideal setting for anyone, but it was a nice space, and it served its goal. But since then, there are progressive Muslim groups throughout America and the United States and Canada, as well as places in Europe. Because I focus on America, there are a number of European progressive scholars in Spain and in France who have endorsed women imams, and there have been, in those cases, as I understand it, they haven't been regular prayer groups, but they've been conferences or one-time events that to demonstrate their support. But in North America, they're ongoing. They are ongoing.
Perhaps one more query. Have you come across discussions about the hadith, which I cannot remember by heart, but I think I am not falsifying? Like
you would be the first.
Yes. The idea that if a woman passes in front of the worshippers, the wudu,
renders them
the ablution is cancelled. They should deal with it, because otherwise we are in big trouble.
Sorry. There's a wonderful book that came out, I think in 2013, by Benem Sadeghi. I don't quite know how to pronounce his name. Sadeghi, thank you. The logic of lawmaking in Islam, and he deals explicitly with that hadith and showing how that was an early tradition that influenced early Hanafi jurisprudence on women. The women can't serve as imams altogether, but pretty soon afterwards, in the following generations, the support for that hadith dropped out. But he shows how it continues to influence later jurisprudence, that their loyalty to early jurisprudence, their loyalty to Abu Hanifa and Shaybani's jurisprudence based on that hadith is maintained, even though they shift legal rationales. They no longer base it on what they call the adjacency principle. I lasted longer than I thought. Go ahead. Thank you.
I saw right, with those bubbles, you put Kaladawi as a Salafi on the Salafi branch, and I imagine you use these terms in an empirical way, not in a normatively, all of them are Salafis and all of them are Wasifis. Treasures in Islam, but empirically, not a single Muslim in the world, including Kaladawi himself, will define himself today as, in terms of slogan, banners as a Salafi. That is understood in contemporary Arabic as the opposite of what Salafiyya in the contemporary sense stands for. It's just, I don't think it's so important.
I've done other work on Qaradawi, and And based on that work, I came to call him a progressive Salafi. But I mean something very specific, and that is, it's too bad I didn't have time for it, but I think his position on this issue was fascinating and shows his creative approach at work. And that is, he's a Salafi in the sense that he feels very comfortable moving among the four schools and very comfortable to put them aside when he feels there's a reason to. He's also very comfortable going back to early non-madhab scholars.
He finds himself a Salafi because what I do is to go back to the origins.
He's not a Salafi in the general sense of.
The way people talk, he's not considered.
He's not a Salafi in the sense that he does pay attention to the traditions of jurisprudence, which for me is the key difference between Salafis and not Salafis. But yes. But Salafis, there are many Salafis who would never identify with them either. Right. Right.
The second point is, I don't think communal interest is the best translation for maslaha. It's the common one, but I just don't think it's the right one. A, because maslaha can be individual interest, and B, because it's not really interest. It's safeguarding the purpose of the Sharia. And when the word interest is used, it's almost as if it's a man-made utilitarian, which is the exact opposite of what Shakir and before him had in mind. I just think for maslaha, safeguarding the purpose of the Sharia is the absolute correct.
But I don't think that's A, I disagree with your interpretation of maslaha, and B, I don't think that's the right interpretation of the word interests. First of all, everything I've read about maslaha is it is public, it is not individual. So I'm interested in terms of classical understandings of maslaha, the primary is the community and the public good. Interests in the way the word interest functions, it can be a synonym of welfare or good, not in the sense of my, not in a narrow how I get ahead, but in the sense of safeguarding the good. But the way that
you know what it means, but I'm saying sort of general audience, when they hear the public interest, it's as if there is some mechanism in Islam. If something serves the public interest, then we can say goodbye to the law. And that's absolutely right.
But Shatibi does use maslaha mursala as a way to bring in innovations that are not but he is. Based on my research in 20th century writings, all the writings I have seen essentially just read from him. He was the watershed on this subject. He's by no means the only person who made important contributions, but it always was striking to me. I got to him through my research on bid'ah, but it was very striking to me that since Shatibi, especially someone like Qaradawi, who loves Shatibi, both on bid'ah and on maslaha, and that there's nobody else out there. It's Shatibi's approach to maslaha.
The radical move Qaradawi made in a very hidden way towards the late 90s was to accept that an individual maslaha in the rank of imams, but never mind that.
No, I'd love to see that. I just have never encountered that. I think he's cool, Qaradawi. Except about what he says about Jews and Israel, but yeah.
I think it's fascinating that's his opinion on this issue. Qaradawi argued that it's permissible for a woman to leave a state. And here it's a great problem because from what you introduced, I understand that there isn't a specific hadith against it.
Well, there's the hadith of Abu Bakr,
which is the exact opposite,
which says which is specifically about political leadership, and it was used.
I'm saying about this issue, there isn't a hadith saying a woman cannot lead a prayer, but there is a hadith saying a woman should not lead a state, and yet Qaradawi somehow managed to contextualize this hadith to make
Right.
it permissible.
Right.
Hamid al-Ghazali, not Hamid, Muhammad al-Ghazali
Muhammad al-Ghazali.
was saying that it's not only permissible, but look at the Israeli example.
Mhm.
Golda Meir, and see why it's...
Look what it got them, right? Right.
And some people will say the opposite.
Right.
That's fascinating.
It is fascinating. I mean, in the written version of this paper, where I can spend more time on Qaradawi, I make the point that he chooses not to make moves, interpretive moves, that he makes in other issues for this one. And I think that has to do with two reasons. Number one is Qaradawi is very mahmir, if you could say it, is very stringent when it comes to ibadat. He's also has pretty stringent attitudes whenever there's male-female interaction. So I think it hit for him a particular, sensitive zone. Well, you're from the Middle East. I'm from America. It's different. Thank you. Oh, sorry.
The comment is general comment concerning this issue. The point that the Sheikh al-Azhar and many other conservative ulama, they are against this, is similar to many other religions. Christianity, let's say, 100 years ago was similar situation. Things has to come gradually. Let's say the Haredim and very conservative or very orthodox Jewish rabbis are also have the same opinion that although the women are equal to men, but they have different duties to do and so on. I think in Islam it will take, let's say, at least 100 years more because it is a jumping situation to give directly to women to be imam. First of all, they have to be equal in other fields, in other domains. So until they become women, let's say 30% or 40% ministers of governments or prime minister in any Arab country, let's say, or managers of companies. So then we come to the religious issue. Maybe, first of all, they can, women groups or organization, they can ask, first of all, that women imama, that means this is instead of imama, a lady, to direct prayer for women group separately from men. Then gradually they can ask for imam or for muaddin, muaddina to give adhan for all people, men and women. So this has to come gradually and not to jump directly. And I think within 100 years, I want to bring an example, let's say in Iran, now they will have problem after 20 or 30 years because 52% of the students in Iranian universities are women, are ladies. The ladies are 52%. During the time, they will become also professors and they will become deans and president of university. They cannot prevent them if they are 52% from being professors. Now they are trying to prevent them. But in the future, it will come. This is what I think.
I attended a conference last week on, I'm sorry? Well, what I was going to say is that I haven't written it yet, but I hope to write one day a comparative analysis on the legal discourse around women. It's a question of what's the good comparison, because there's one comparison between women imams and, let's say, the whole discussion of can a woman be a rabbi, starting back in the 70s. But I think the more appropriate parallel is what's going on currently, what are called partnership congregations, where a woman becomes the prayer leader for men in modern Orthodox circles. And I was at a conference last week on that subject. And it's they're very interesting the legal moves are very similar, and the returning to early sources that are discarded by the subsequent legal tradition in order to show that there was an original intent to allow women, but was squashed by male patriarchy, etc. There are all sorts of interesting comparisons to be made. There are now, the rabbi, as someone has said, apparently Tamar Ross, who's a professor of Jewish philosophy, has said that train has left the station. There are a number of programs now of modern Orthodox institutions of learning that have started to appoint to ordain, that's the word, thank you, to ordain rabbis, a program in New York called Maharat. This is their second year. There is a program here in Jerusalem at Midrashat Lindenbaum that ordained 2 women already. There's a woman in California who is an ordained rabbi by, so that's happening. I mean, that's an interesting process in itself. But anyway, that's for another paper. Thank you.